Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, special community property problems and division. Let's begin. Advanced community property essays often involve assets that do not look like ordinary bank accounts, a professional practice, business goodwill, retirement benefits, stock options, educational loans, or life insurance. These problems test whether you can separate acquisition, labor, risk, and timing. The governing principle remains the same. Community property is built from marital labor and earnings, while separate property belongs to the spouse who owned it before marriage or received it by gift or inheritance. But apportionment is often required. Do not panic when the asset is hard to value. State the characterization rule, identify the community and separate components, choose a reasonable apportionment method, and explain the consequence at divorce or death. California bar graders reward a practical, organized answer more than perfect arithmetic. Business interests. A business owned before marriage is separate property at inception, but the community may acquire an interest in its increased value if community labor contributed during marriage. A business started during marriage with community labor or funds is presumptively community, subject to tracing and reimbursement. Pereira allocation. Use Pereira when the spouse's personal skill, effort, and labor were the primary cause of business growth. The separate estate receives the original value plus a reasonable rate of return, and the excess growth is community. Van Camp allocation. Use Van Camp when the character of the separate business, market forces, capital investment, or employees were the primary cause of growth, and the spouse was reasonably compensated. The community receives the reasonable value of the spouse's services during marriage minus compensation and family expenses paid, and the remaining growth stays separate. Goodwill. Professional or business goodwill can be community property to the extent it was developed during marriage. Goodwill is the expectation of continued patronage, not merely the professional's future earning capacity. It may be valued by expert testimony, capitalization, market evidence, or other accepted methods. Retirement benefits. Pension and retirement benefits earned during marriage are community property even if not yet vested or matured, because they are deferred compensation for marital labor. The community share is commonly calculated by the time rule, service during marriage divided by total service, multiplied by the benefit. Education and training. Education itself is not community property. A professional degree is not divisible as property. However, California provides reimbursement to the community for community contributions to a spouse's education or training that substantially enhances earning capacity, subject to statutory exceptions. See FAM. Code Section 2641. Choosing between them. The methods are not rigid formulas. The court selects the approach that achieves substantial justice. On an essay, explain both if facts are mixed, then choose the better one. Key facts include whether the spouse's skill was central, whether the business was capital-intensive, whether compensation was reasonable, and whether growth tracked market conditions. Note: if the business was created during marriage, start with community characterization. Pereira and Van Camp are most important when a separate business increases in value during marriage. Goodwill is commonly tested with doctors, lawyers, accountants, dentists, and small business owners. A professional practice may have tangible assets, receivables, and goodwill. Goodwill exists if clients, patients, or customers are likely to return because of reputation, location, name, systems, or referral networks. California treats community goodwill as divisible property at divorce. The fact that goodwill depends on the professional's future efforts does not eliminate value, but the court must avoid double counting. Future earnings used for support should not be counted again as property without care. Goodwill is distinct from a license or degree. A law degree is not property, but a law practice's goodwill developed during marriage can be. A medical license is not divisible, but an established medical practice may have goodwill. Retirement benefits are deferred earnings. If earned during marriage, they are community even if payable later. The non-employee spouse has a community interest in the portion earned during marriage. Vested versus non-vested. Vested benefits are not forfeitable. Non-vested benefits may still be divisible because they represent an expectancy earned by marital labor. Matured benefits are presently payable. Unmatured benefits are payable in the future. Characterization does not depend solely on maturity. Time rule. The community fraction is marital service divided by total service. For example, if a spouse worked for an employer for part of the marriage and continued after separation, the community receives the fraction attributable to service during marriage. Education is not an asset to divide. The community does not own a spouse's degree. But if community funds paid for education or training that substantially enhanced one spouse's earning capacity, the community is generally entitled to reimbursement with interest under FAM, Code Section 2641. Exceptions. Reimbursement may be reduced or denied if the community has already substantially benefited from the education, there was an express written agreement to the contrary, or the education reduced the need for spousal support. There are statutory presumptions about whether the community has substantially benefited depending on the passage of time, so mention the concept without inventing facts. Student loans. Debts incurred for education are generally assigned to the educated spouse, not divided equally, because the benefit follows that spouse's enhanced earning capacity. Still, analyze timing and statutory treatment rather than applying ordinary debt division automatically. Divorce. At dissolution, California generally divides community property equally unless a statute provides otherwise. See FAM, Code Section 2550. Quasi-community property is also subject to division. The court may order reimbursements, offsets, and reserve jurisdiction for pensions or difficult assets. Death. At death, a spouse may dispose of only that spouse's one half of community property by will. The surviving spouse already owns the other half. Separate property may be devised by the owner, subject to omitted spouse and other probate rules not usually central to a community property essay. Quasi-community property at death. California gives the surviving spouse protections in certain quasi-community property, but treatment differs from divorce. Be precise. Do not simply say all property is divided equally at death. Death involves ownership and testamentary power, not dissolution equal division. Dividing a degree as property. The degree is not property. Reimbursement may be available. Using Pereira automatically. Choose Pereira for labor-driven growth and Van Camp for capital-driven growth. Forgetting goodwill. A professional practice can have divisible goodwill even though the professional license itself is not divisible. Treating unvested pensions as separate. Deferred compensation earned during marriage can be community. Applying divorce division rules at death. At death, each spouse owns one half of community property. Only the decedent's half passes. Ignoring post-separation service. Pension and business value after separation may be separate to the extent attributable to post-separation labor. A high-yield essay may combine a premarital dental practice, a pension, and student loans. For the practice, determine whether growth came from the dentist's marital labor or from capital and staff. Discuss Pereira and Van Camp, choose the better fit, and address goodwill built during marriage. For the pension, use the time rule and note that vesting is not required for a community interest. For education loans, state that the degree is not property, but community payments for education may trigger reimbursement, while remaining education debt is usually assigned to the educated spouse. Conclude with the procedural setting. If divorce, divide community and quasi-community property equally and order reimbursements. If death, identify what the surviving spouse already owns and what the decedent can transfer. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.